guys think that there's anybody in the jury that doesn't hear Hank the way that we do?
We could put up page 33 from Dr. Welcher's PowerPoint.
Because it gives him more time to bring his witnesses' statements in. That's what he's doing here, in my opinion.
So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data?
Thank you for the follows, guys.
See you at sidebar.
Sidebar. See, every time that I pause and talk, it's for a reason. It's so we could skip the sidebars. Every little bit counts. Every little bit. He's making me a nervous wreck. I have to open my cashews because, damn. Do you guys have your cashews? Yeah, we're behind by just a few minutes. Did you? Pistachios.
Come on.
Thank you. Salt and pepper. I love me some cashews too. What is in that baggie? Mr. Yannetti, sir?
So jurors, we're going to release you for the luncheon break. I took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you.
Because I used my ESPN to tell you guys that you need cashews. That's why you were staring at them. Hi, how are you? So they're going on lunch.
Rise for the jury.
Maybe that's what we should change the name of this. Maybe that's what we should change the name of this channel to. Crime and Cashews. Oh yeah, I always say ESPN. And the funny part about it is every single time I have somebody thinking I mean the damn sports. Who missed, 1 second, guys. Want me to try to save, okay?
Yep.
Yeah, right? Who missed the motion to dismiss? Veronica messaged me about that. Okay. Not like we have anything better to do with our time because they're on lunch.
Mr. Jackson. Sure.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts.
That was Matthew DeSogro from Delta V.
There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on
We're glad to have you. New people are always welcome here.
circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove,
Innocent.
and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date.
Guys, this is before court started today. This is essentially the motion to dismiss. And this is Alan Jackson making his argument. Jury is not in there.
The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning.
Thank you for the follows, guys.
Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there was not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian.
We're not there yet, Noel.
Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind him. The dome light was on. They could see inside. the interior of the vehicle.
If we go based on who they've called so far, it should be today as well, if not today, within the next day or two. The witness they just had was one based on that as well, so I would imagine it will be pretty soon here.
Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03.
Should be, Kathy.
And again, the Commonwealth's chief medical expert,
But don't forget the with prejudice part.
Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body. The only person to have physical access to John O'Keefe testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that she that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case.
point,
They've
Gunter.
done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts, and certainly taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
This was the motion to dismiss this morning. You want to hear what good old Hank said, right? He has to have a really good argument, right? Totally good argument.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication.
Hank, If we look into intoxication, do you want me to list the number of people that were intoxicated and out that night that could have done this? Seriously?
A reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion, and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just two of the cornerstone pieces of intoxication, which are clear, light, most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's.
This was, well, right before he got up there, AJ did a motion to dismiss. This is his argument against a motion to dismiss.
Own Lexus.
Yep, he wasn't the only one, remember? Somebody left their badge and firearm inside that vehicle when they went out drinking.
From her shattered right taillight that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour.
No jury.
He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight.
Thank you.
The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data.
That's a really good question, Teresa, but we can't do that because that would make sense. No, they're not done.
And again,
They're on lunch.
Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming.
Because
It
it's
is a
already
public
been
way.
destroyed.
Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions that night, after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death.
If that was the case, sir, a lot of people in Canton would have ended up in that same outcome. The hell is he saying? Do you guys see how close we are to 100 subscribers? I've never been at 100 subscribers before.
There is no predicate of
pretty cool.
intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself.
Thank you for the
Through
follows.
firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells
Thank you
us that
for
when she leaves, he
subscribing,
doesn't.
Lisa. I appreciate it. Welcome to the subscriber family. Now, when you go to type comments, there's the emoji for the smiley face. Next to that is the star. That's how you use your subscription stickers. And there's lots of them.
Look mortally wounded. She
Thank
leaves
you.
him, makes dozens and dozens of calls, but never goes back to help
That's
him
one of my
and leaves him
favorites.
to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments. On the other topic that we were discussing at sidebar, I don't need to hear our,
Yes, that's right. She instantly said denied. To all three. What does he mean about she haven't clipped him? No, that's not what she said. She said, did I hit him? Could I have hit him? And he's just glossing over that, pretending she never said that first. They're on lunch break right now, you guys. So we went back to the beginning where how today started, which is we were on. I had to jump on early because, of course, he was given a really damn good argument to have this all thrown out. So I got hopeful. Silly me for trying to be a glass half full kind of girl in 2025. I should learn my lesson. But I tried. I thought, but no, sadly, it did not happen. Well, you guys remember how good his opening statement was, right? I'm going to be honest with you guys. I knew nothing about the case, not really, because we made that oath to not research it. But I actually, at first glance, did make a prejudgment on Karen thinking she was guilty. And I didn't even do it on purpose, but I did it. And I don't like doing that because that means that I made a decision without knowing the facts. But it's the truth. I did think she was guilty. I just didn't know what I thought she was guilty of. Opening statements happen. 5 pages of notes later, I changed my mind. Exactly. This is not a comfortable spot to be in. I cover trials. I cover true crime. I cover news. This is what I do. So I've never been on a side of a case to where I was rooting for the defense and that I even liked the defense attorneys either. I've never been on somebody that's getting charged. I've never been on their side because I haven't seen the corruption to such a level. I have never seen it like this. Not for a trial that we're covering. So it's a wake-up call. And that wake-up call is if they could do this to her, they could do it to any one of us. And that is scary as hell. Yeah, there's a lot of that too. And then we cannot forget the witness that they had up there good old yesterday, which the day before that, he was getting text messages on his smartwatch while he was on the stand. The hell? And Bev didn't even make him take off his watch. There's already a petition. There is a petition to get rid of Bev. It is in our Facebook group, Criminal Musing. So if you're not in that group, go join it. There is a change.org petition. We have it pinned in there. But keep in mind, she did just get Person of the Year. And this isn't the only case that they protected each other in Canton, now is it? No. Cynthia probably won't, but we're trying to be positive and proactive. I'm always the glass is half empty. I'm really trying really freaking hard this year to be a glass half full kind of girl. They're making it really complicated. I mean, 2025 started with, we all know how 2025 started. I'm still trying though. I said I'd try. I'm trying. Yeah, I know. Sandra Birchmore, yeah. It is glam, it sure is. The first witness, I think the first witness went really well. Not when Hank was questioning. Hank was irritated. One thing about Hank that I've noticed, he cannot hide his emotions, how he feels, or how he thinks. Do me a favor, Johanna. Google Sandra Birchmore and see what pops up. You'll understand why. We can't say the K word, guys. Please don't say the K word. TikTok thinks we're 5. They do. They really do. All right. So the rundown on Sandra Birchmore. When she was under 18, She was in a program they had in Canton, and it turns out that since the age I was at 15 or 16, they were grooming her and hooking up with her. Then one of them got her pregnant, and she was found dead. I'll let you find out the rest. You're 5.5. I wish I was 5.5. Can I petition for it? Guys, please don't say the K word. TikTok thinks we're 5. They do get people in trouble in the comments. So if you use the K word, you can get in trouble. So be careful. I don't want you guys to get a restriction because of it. They've changed a lot of the TikTok terms. So I just don't want you guys getting in trouble. Yeah, that, I hate that word, but yeah, that's okay. Makes 0 sense, but yeah. It does have cool lights. The one that is followed by ILL. That word. Yeah, Parker got one. Just for typing in the comments. Essentially, yeah. That's why we say unalive or smurder. And I hate smurder and I hate unalive, but I go with unalive more than I do the other one. It's ridiculous. It really is. It really, really is. All right, let's see where we are at with... They're not going to be back for half an hour. Tiller works. Yeah, we have to use our safe words, guys. I hope you all know what those are. Well, there's video of the last time that she was seen, Sandra, going into her apartment. Oh my God, you guys. Okay, so we had my mom's birthday on Monday. You guys are never going to believe this. My sister brought her a pineapple upside down cake. And I just busted out laughing. Some of you know why I busted out laughing, because I recently learned what an upside down pineapple is. And then she just rolls up to my mom with an upside down pineapple cake. So I just lost it. I did. I really did. And I instantly thought of you guys. And I'm like, I wish you guys could have been here to see this. I'm just... Somebody remind me to call my sister later and let her know what an upside down pineapple is. It's a cake, upside down pineapple cake, but maybe not do upside down pineapple cakes anymore. I recently have learned, there's so much to learn on social media, that upside down pineapples, some people have them on their porches and stuff, I guess. I've recently learned that that means that they like to go on swings as couples. Do you? I've never had it. But instantly, that's where my mind went. Because you guys all had to tell me what it was. And I felt so stupid. So when I saw that she had brought one, I lost it. I really, really did. What about flamingos? Y'all didn't tell me anything about flamingos. And I want to be abundantly clear. I am not knocking. If any of you are swingers, more power to you. Do your thing. I'm not knocking it. I'm just saying people that aren't swingers should probably know not to put upside down pineapples on their front porch. I thought everybody had flamingos in Florida. The Villages? Oh gosh. I thought everybody had flamingos in Florida. Y'all are telling me that you can't have flamingos now too? One day I had in my mind that I'm going to move to probably Florida, so now I know I can't have pineapples or flamingos. I know, but it's a pretty bird. So now you guys have ruined flamingos for me too. Thank you so much. Thank you. Thank you so much, guys. All right, you guys wanted me to check on Diddy updates? Hold on. They're on lunch. Don't worry. We have half an hour. I really don't like this not being able to fast forward thing. No, do not tell me anything about pizza parties. Do not ruin pizza for me. I'm a food girl, clearly. Do not ruin my pizza. Do not ruin my pizza. I will not forgive the pizza ruining. I will not forgive that. I really won't. You don't come between me and my pizza. Now I really want pizza. And don't think that means something else. Oh, shit. Okay, what do we have here? You guys know that for Lori Daybell, another judge had to see her because she put in another request to get the judge thrown off the case. I'll just leave that where it is. You could ruin tortilla chips, but don't touch my pizza. I really do want a good Chicago style pizza now. All right, let's see. And if you guys are going to ask me if I'm going to play the Chris Lee's release from prison thing, I'm not. Just so you know. Not. Ooh. So here's an update on Crystal Rogers' case out of Kentucky. Steve Lawson deleted phone calls. For those of you that know, you know. Don't look at what? Oh, and you guys do know that Brian Koberger's team has submitted a lot more documents. And that does include a possible alternate suspect. Don't know who it is because that is under seal. What do we have? They still haven't found the ex-police chief escapee. Really? I haven't heard they might have found the weapon. If you see somewhere that says it, please share it to me. What else do we have? Now you guys gotta understand why I'm not clicking on every news thing that has Diddy's face on it. Because I can't play 98% of what they say. So I'm just looking for one that will allow me to appropriately mute the things I need to. Deontay Nash testified that Diddy threw him out of the car and started trying to strangle him. Thank you. That was 34 minutes ago, so that's what happened in court today. Deontay Nash, Diddy threw me out of the car and started choking me out. What else do we have here? That was hilarious. That one was hilarious. I had like 5 people send that to me. Yeah, yes. We actually follow each other. Hold on. Chris Rogers, yeah, one sec. Well, you know, let's do that one first. Hold on. Let's do Crystal Rogers' first. And just so you know, there's no cameras in the courtroom for that one. So we can't see Crystal Rogers. I don't know what Usher said. Usher testified already? All right. I'm going to put this on speed up so we can get through it. in enough time. Just a little. Out of Kentucky.
Bombshells, more than one. The theme of day number 2 in the Crystal Rogers Bardstown murder mystery trial. Hello, everybody, and thank you very much for joining us for this special report on WHAS 11+. I'm Doug Proffitt. Steve Lawson is on trial for his role in the alleged...
I believe I do have a tab for Crystal Rogers too above my videos, guys.
cover-up of Crystal Rogers' death. Remember, cameras have been banned by the
Damn.
judge from covering this trial, but our reporters are sitting right there in that Bowling Green courtroom. They're taking very thorough notes. Plus, we are joined by WHAS 11 legal analyst Nick Mudd of the Mudd Law Group. He's going to be coming up right away. But first, Shay McAllister and Isaiah Kim Martinez are covering the trial for us. We want to begin with Shay. Shay, the prosecutor throwing one of those bombshells, calling the chief suspect's brother and mother co-conspirators in Crystal's death.
Yes, of course, Doug, this is something that stood out to everyone because Nick Houck's involvement is always a lingering question in this case. It actually got brought up by one of the defense attorneys who was asking Jon Snow, former lead detective, is there any other suspects in this case? Is there anybody else that they're considering? And Jon Snow said, well, we've never named any other suspects, which of course they haven't, just
Right.
Brooks Houck on record. But the defense attorney kept pushing, saying, well, who else is listed in the file? There's other names in the file. That's how Nick Houck got brought up for the first time. The exact quote here was Shane Young asked, are you aware of the filing in this case that Nick Houck and Rosemary Houck are co-conspirators? And he said, of course, yes, in that case. He also said Nick Houck was a police officer who would be the best person to plan out a murder, and the judge cut him off there, which very interesting. He was trying to go somewhere with that.
Sure, and it's interesting, you reported, Shay, yesterday when this this trial was just starting, before jury selection, right? Defense attorneys made one last-ditch effort to try to say, hey, we haven't had enough time to review all the hundreds of thousands of pages of documents, and they mentioned Nick Houck as a potential reason or things that could come up, things that they wanted to make sure they were buttoned up. So we continue to hear his name, and now, of course, Brooks Houck's mother's name brought up. Who knows, going down the line if we hear them again.
There's this inference that they're connected, that they were part of this, but still, Isaiah, we've had no details on how. And honestly, not sure that comes in this trial or even the next trial, but Doug, that is something everybody's interested
They're on
in.
lunch, yeah.
Yeah, as you know, the brother and the mother, they aren't charged in this case. They've long been talked about by the folks at Bardstown over the past 10 years. What was the reaction in that courtroom when the prosecutor threw that out?
It's a good question. Everyone in the courtroom was asked to not react, though, to anything. I mean, specific instructions on day one, no reactions, no signs, no writing of any kind. So even, Doug, when there is a big moment like that, when you look around, everybody stays very calm and quiet.
Although you can always tell with reporters, right? Whenever we're in the newsroom, or in a trial like that, everyone sort of leans in, saying, like, did we just hear what we just heard? And I'm sure that was the moment. I wasn't in the courtroom for that, but you were. I'm sure that was some of your fellow news members were
Of
doing
course,
that.
yeah, the journalist ears were perking up.
Well, Shay, another point I know we want to cover here. The prosecutors also called a witness to dispute why Houck and Steve said they had a late-night phone call the night of Crystal's disappearance. Houck, in one of the very first police interviews between Detective Jon Snow, who's been testifying, calling him from the interrogation room. Here's what was said.
But I just want to tell you, I'm sorry about everything going on in your life, brother, and I got you in my prayers.
I said it is a very difficult and trying time, but I appreciate you saying that. But hey, I need your help while I got you on the phone here. Do you remember the other night you called me really, really late, and I forgot what you asked me. Can you? I guess it wasn't on the phone. I might have been tired. I know it was pretty late at night. Can you remember what you asked me or what you were after? I can't remember.
Yes, sir, I can. I called to ask you for them numbers for our house.
Oh, for a rental house.
Yes, sir, I did.
And what did I forgot? What did I tell you?
You told me that you would call, what's her name, Katie or whatever, she handles all that.
Crystal.
Crystal, okay, I apologize.
Yeah.
And she said she handles all that, and that you would get back with me on it.
All right. Thank you so much, Nell.
Hey, if there's anything I can do, you give me a call.
Thank you. You have a good night, Nell.
Yes, sir, God bless you.
Thank you.
So that clip right there is such a critical part of this case. Shay, you've watched it over and over again. Certainly it's going to be a big part of the next case starting June 24th. We just heard Steve there saying he called Brooks that night because he had a question for Crystal about a rental property for his ex-wife's daughter, Lauren Harden. Lauren Harden was on that stand today disputing that.
Yes, exactly. And not so much disputing what was said, but disputing some of the reasoning behind it, which was so interesting. This is one of those names that we've never heard. And today was full of them, names that we've never heard, people who we didn't even know were actually players in this case.
Even connections that are hard to sort of draw on paper.
Right.
You almost have to hear it one or two times
Right.
to know. Yeah.
And she was one of them. So Lauren Harden, she is Steve Lawson's stepdaughter. During that call, he says, I'm looking for a rental property for my stepdaughter. We learned today that she was unaware that he was looking for a rental property for her. The exact quote was, Shane Young, the prosecutor, asks, were you looking for an apartment to rent? Lauren said no. Shane Young said, did you ask him to call Brooks Houck for an apartment? Lauren said no. She actually went on to say that she had rented from Brooks Houck and Crystal Rogers previously, so she had their numbers. She could have called them if she was needing an apartment, and she didn't.
Of course, the defense, though, had...
Yes, and...
Yes. But it's not like that. It's BROUCK.
brought up some of her past
cameras.
apparent drug use, Shay,
Right.
which in a way I'm sure the attorneys were sort of trying to discount maybe some of her memory of what she needed in that moment or conversation she had.
They did. They did point out, and she admitted that she was using drugs during this period of time. She was addicted to drugs during this period of time, and I think the question was, so that could have impacted your memory, and she said, sure. So that definitely a good note there. But that wasn't the only person who's close to Steve Lawson that we heard,
I love the TikTok shop. The TikTok shop is great.
who has a similar connection, a little bit different, but another stepdaughter of sorts, although her mom was not actually married to Steve Lawson. Her name was Elizabeth Chesser, and she has a child with Joseph Lawson. It's difficult to follow, Isaiah. You and I were talking through this earlier.
It takes a few times to say it, right? This is Steve Lawson's son, Joseph, who's also charged in this case. His trials later. A woman that he had a child with, or shared a child with, that is who we're talking about, Elizabeth Chesser. So she was very connected to the Lawson family, and Steve Lawson as well.
Yes, exactly. So she comes in because she heard a comment that Steve made. She says that Steve had said he was planning to leave his ex-wife, Tammy, because Tammy knew that he had committed a murder and she was going to tell on him. That was the exact quote. And this was considered another bombshell today, that there had been discussions of a murder committed, that people knew about it, and then nothing was ever reported to police here. And they actually did say, Darren Wolf, who is Steve Lawson's attorney, did say specifically, why did you not call the police? If you thought that this man who is living in your home or near your home had committed a murder, why wouldn't you call police? She said, I would be next if I had said anything.
Shay, you really get a sense, too, of sort of how prosecutors specifically are trying to build this case, essentially saying, here are people, in their words, right, who say that they were afraid to report red flags, again, in their words, because of possible retribution. Again, that is the case, you can tell, prosecutors are trying to paint to the jury.
Exactly.
All right, we'll be back to both of you in just a minute. Shay, I'm glad you brought up the committed murder comment. Nick Mudd is joining me here. That has fascinated me all day long. Nick.
That's a lot of updates. Yeah, and Crystal Rogers. That's a lot of updates. That's good, though. I'm glad that they have all that extra. Especially the fact that chick was never even looking for a place to live. And I saw you guys' comments that Diddy was a devil. Don't forget, someone put him in the position he's in. Somebody opened that door for him. Not that I'm saying I'm saying that there's somebody that's worse. There's someone bigger in Hollywood. And you guys know that Drake was supposed to take his place. That clearly didn't work, though. Alright. Next thing on our watch is Lori losing it on the judge 16 hours ago.
Depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, you have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate, independent hearing, then there's no penalty phase. So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
They're on lunch, so we're catching up on what we missed with Lori yesterday.
No.
So are we
Sure
going to
did.
have a whole nother aggravator phase in this case?
If
On
the jury
Monday.
finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No,
Lori Daybell.
They're just alleged aggravators.
correct,
And the grand jury never found probable cause for them.
correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that?
That's what I said.
Okay. Hold on one second.
She is defending herself
You have
again.
the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases.
No, we will. We hear from her a lot because she's her own lawyer.
I know in capital cases, they call it a Comus hearing, but this is for non-capital case.
No, and if you want to see her in action, I have her last trial on my YouTube. There's a section for that under Lori Daybell. Don't miss that one. Thank you.
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16.
You're welcome.
Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant caused emotional or financial harm to the victim's family.
Today's your birthday? Her next trial, which starts Monday, will be for conspiring to unalive her niece's former husband. How did I not know it was your birthday? Thank you. We're starting at 8 on Monday. I won't make us hear the kids' voice singing, but it's a tradition. We play the birthday for everybody. So happy birthday. We love you.
The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were
They're due back in 10 minutes. Whether or not they'll be back in 10 minutes, totally different question.
found guilty by a jury of
But not
the
much
charged
longer.
offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty, for example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
Nora, you're the one that pushed for a speedy trial, but yet you're asking for more time. Make up your mind.
All right. 13.5e talks about amending the charge or the indictment. Okay, your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole other allegation. It's a whole separate allegation.
Difference between an aggravator and
No.
changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause.
Not live.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for
Oh,
the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge, is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun Usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve? In this case, with this charge, with one statute, you can't give me less time, you can't give me more time, you can't do anything else except for, there's just one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
Right,
You're the one that wanted a speedy trial, Lori. Nobody else but you.
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators. Being a dangerous offense and these specific
aggravators. Can I finish what I said? What I was saying?
Right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So
no dangerous instrument or deadly weapon was used.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators?
Correct.
Before trial starts?
Because you're not entitled to one.
Thank you, Lisa.
Okay.
13.5 says that you're entitled to a probable.
You'll understand the don't flatter yourself one when you watch the last trial. Trust me.
Cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference.
It's an extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous.
Actually, I even did a short video of it. It's under her tab. You'll understand then too. No, that was her first trial. She's already been found guilty of that. They just finished her second trial where she was on trial for conspiring to unalive her fourth husband. She was found guilty of that. This is her third trial for conspiring to unalive her niece's former husband. She's a busy girl.
Allegation because it's changing the charge and it's changing the sentence that you would be getting. These
That's exactly my point. How does, after the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change it?
Lori, choose your battles. You're already serving life without the possibility of parole on 3 counts. Choose your battles, girl.
Anything.
Probably nothing in reality. You just said it. They don't change the charge, so you're not entitled to a probable cause hearing.
Sure, then I don't want to have an aggravation phase either.
Well, you can,
Are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
well, if you don't want to attend, you don't have to attend. What else?
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult.
Even her own. There's even belief that she was the one that unalived her third husband, but she had him cremated right away, so they can't go back and check.
For them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you're going to check into that. Is that something that you did check into and there's no more available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have beside yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing because you are acting as your own.
Okay, you guys remember at the beginning of the first trial, I said I wasn't exactly sure how I felt about this judge. I've changed my mind and I want to make it official. I like him.
An attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
He's definitely no Darrow, but he's close.
Appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then it's an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think
time.
it depends on the complexity of the question. If it's a simple jury question, that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the...
If I was him, I wouldn't want Lori Daybell up there at all. She is a convicted unaliver. I would not want her up in my area. No.
bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay.
We'll be going
I have
back
one
to
more issue.
Karen in a minute,
Go
guys.
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require
They're
an answer.
scheduled to start back up 5 minutes ago, but they have not started yet. They never do start on time.
About prior testimony or prior proceedings.
Thank you.
State agrees, right?
Yes, sure.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or prior proceeding, that maybe we should take a break.
Okay.
All right. Anything else?
That was it.
All right. We'll see everyone.
She said,
All right, they're ending that, so we'll go back to the courtroom for Karen Reed. And I'm going to mute for a second so I can blow my nose and you don't have to hear it because that would be gross. So 1 second.
gentlemen, if we could turn to page 6 of Mr. DeSorga's amended PowerPoint presentation. Sir, I want to ask you about your opinions, and inevitably, some of the slides that you presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when
I didn't know that, Christina. Thank you for saying that.
the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
See, Christina, I have too much anxiety to see people's reactions. Nope. I polite pass on the drama.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is, with the other chips, part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
That's what Hank does best, is draw things out. This is still Matthew DeSogra from Delta V.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So,
and that is one of the reasons why when we have trolls come in, I ask you guys not to react, because they want a reaction.
that 3 seconds
She sure does.
that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on,
Why is it long, or why do I think it's long? I think it's long because he, as we know through this whole trial, he's been trying to fill our heads, confuse us, and make us lose track. That's just my personal opinion. I think he just has a bone to pick.
infotainment system clock does not accommodate
I'm happy
that 3
that you are,
seconds.
Lisa.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where...
Are you asking or telling him, sir? Because there's a really big difference, and I object to you telling him something instead of, rather than asking, you're supposed to question him. Guys, I think I should pick one person and give away a subscription today, but don't tell Aaron. So I'm going to be looking.
He cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report, where in his
Objection,
report does he
100%.
say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here, if you can give me the page.
You know what? I am so glad that you found a four-leaf clover. With Hank, we'll need the luck because that man doesn't shut the hell up.
We will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Objection, Your Honor.
Sustained.
So, when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess' report and you learned that he and others, betting yourself, you simply relied on reading and reviewing Mr. Burgess' report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess' report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess' findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report, where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Objection, Your Honor.
Hurts mine too.
When you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess' report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
We're actually about 30 seconds behind, but pretty much, yeah.
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I
show.
know, that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe the infotainment clock begins when the infotainment system goes on? We just spoke about that, correct? You're adding 3 seconds
that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra, it's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delay. Is the alignment between those, because the VCH key on time is on, and that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify.
Sorry about that, guys. I was trying to send out the random subscription and it froze me. I apologize for that. But it looks like it did get sent out. Who it was sent to? Patricia, you won. You got the free subscription.
I have not seen
Yeah,
a timestamp from
Sorry.
a key on event in a Lexus.
Sorry
The
about
fans
that,
on,
guys.
I'm trying to
I know
show.
that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3 second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
Thank you.
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3 second gap, do you think maybe you made a mistake in considering it that way?
No.
Okay. The time that you're adding 3 seconds to is the
We're more like maybe 2 minutes behind.
infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra, it's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if
Catnip just sent a free subscription too. Laura, it was you. You won. Thank you, Catnip.
the vehicle control
Appreciate
history
it.
had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know Mr. Burgess actually looked at the data, not just the timestamp. He looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data?
There is no timestamp on the text stream data, is my point. It's a derived value from the key on time, and then added to that
Thank you,
is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You look at the raw data?
I've never made it to 100 catnip.
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent
Right.
system from the infotainment, and you said from, so
Pardon?
they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3-second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3-second delay,
I don't know.
and that needs to be accounted for
Showers
if
pipe
you're going
again.
to correct the timestamps. However, the caveat I put on that was that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know.
There should be. Maybe you guys should bring that up at the next Bar Association Person of the Year meeting.
From testing other Toyota systems that the key on timer happens
Should.
almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this
This is the defense's witness.
case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
your
this
suggest-
specific Lexus.
I'm sorry, finish.
No, just I'm
You're not sorry.
clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the runtime
Bye, Heather.
in their exemplar, so we don't.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. If we had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same?
By the way, guys, this is not an airport. You don't need to announce your arrivals and departures. But I wasn't talking to you, Joanna. I was talking to the other one. You're gonna run for cashews? I need a refill too, please.
Same, or is it unique? We don't know. The answer is we don't know.
No, it wasn't to
And
you.
so when you're determining that 3-second variance, you don't have any assurance in your own mind.
When you go to do the stickers, where you type comments, next to it there's the smiley face emoji, and next to that there's a star. When you press the star, that will bring up all the subscription stickers.
Whether or not this car, Miss Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct, and that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now, let's turn to slide 9. As part of your charts,
Okay.
could you enlarge left, please? As part of your charts, you took this chalk from Attorney Burgess's report, and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
apply the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14:13 a.m., 4:38:16 a.m., 4:42:06 a.m., 4:45:12 a.m., and 5:04:28 a.m. You said on direct examination, oh boy.
There's your sign, Hank.
You said on direct examination that was matching infotainment to iPhone.
You got it.
That's what it says on the chart, so
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion, that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matched to John O'Keefe's iPhone or some other phone matched to John O'Keefe's iPhone? Did you do any independent study about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know?
Hank, chill.
That at 1:14:13 a.m., the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 columns. Do you know where that information came from?
It came from the SD card from the infotainment.
Yeah. Do you know where the genesis, the beginning, the source of that information? That matters, right? The source.
It
It's
would.
like pulling
It would.
teeth.
You know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And that's,
And crooked.
Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the
No way,
infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
Holy hell. We got to roll that back. I think we have a
You know
hostile
the genesis,
questioner.
the beginning, the source of that information. That matters, right? The source.
It would.
It would. You know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And that's, Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
You went too far, Hank. But you know what? Keep on doing that because the jury sees that and you look like an asshole. I cannot believe he said that. Does he not realize how he's coming off to the jury? One more time.
Infotainment when a phone is synchronized after the fact.
Blaming answers is not gonna get you out of answering the question. Did you know?
Sustained.
Sure.
Avoiding answers is not going to get you out of answering the question. One more time. Have to close your eyes. Sometimes if you close your eyes, it helps heighten your other senses.
Jury, show the jury. It relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John Keith's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m. the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 columns. Do you know where that information came from?
It came from the SD card from the infotainment.
Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming answers is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
I cannot make out that first word. Let's put closed captions on.
Source of that information, that matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming answers is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
Lori, or Lore, you rock. Blaming Aperture is not going to get you out of answering the question. Thank you. Yep, you got it. Hanky Panky getting impatient. Your true colors are showing. Why he thought that was, you know what? Keep doing you, Hank. Keep doing you. Keep on. Hank's sweating.
Do you know the genesis, the source of those 4 numbers?
Definitively no.
Your entire premise for your size and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those...
I'm not entirely positive, but I think it has something to do Parker says because of the state she lives in. That could have to do with it. It could have something to do with her being retried again too. I just don't know. I'll look it up on next break if you remind me.
Are all phone calls from the defendant's phone to Mr. Ortiz's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
between, sorry, can you maybe just state it more clearly? Because I'm not sure, I don't want to fumble through an answer if I don't understand the question. So
Do you know where those calls came from? The source?
a phone,
Whose?
Miss Reed's phone.
A phone.
I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, plug your phone in, it's going to register on the infotainment system, but come from the phone? Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them.
Right.
And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure, if there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that
When an iPhone is plugged into a car, it downloads the information from the iPhone on the infotainment system? Do you know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a target if you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection. So,
That's a dig in.
strike that, go ahead and ask your
I
question.
apologize.
Bullshit, your apologies.
We have two different devices, a Lexus clock, the infotainment system, and an iPhone. You would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, do you agree that you would expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
Two iPhones?
Yes.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely two iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other? Objection.
Sustained.
Do you have any opinion about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree with all of your assumptions and conclusions are inaccurate?
They're not iPhone to iPhone in the sense that column 1 came from the infotainment.
Have a good night and stay safe. I love you too.
The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Assisting.
So this is iPhone to iPhone. Then your assumption on the first five, 1, 2, 2, 1, 2, 1. If they're iPhone to iPhone, and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they? Objection.
I'll allow this.
If the title of the
Alright,
first
PT.
column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is,
Do you
those
though?
first five calls
No.
were iPhone time to iPhone time. If you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they? Objection.
Assisting.
At 5,
Bev, this might be a good point for you to say, about how much longer do you think you're going to be, Hank? You know, like you do the defense every damn day.
21:36, do you know whether or not the defendant's Lexus was on?
Yeah, we.
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are two different numbers, 5:30:15, 5:30:52.
Good
Yes?
question,
Yes,
Chastity.
Right. And do you appreciate that that is two separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Birch's report as I recall it, in that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is
Yes, Sue.
there were two calls placed,
Well, sort of.
there were two call logs in Mr. O'Keefe's phone, but only one timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at
Enjoy.
phone records for the defendant or for Mr. O'Keefe to make a determination whether these are two separate calls or not? Did you ever do that?
No.
I'll give you a very quick recap. Started with the defense asking for the case to be dismissed. Surprisingly, Beth said no. And this is the first witness, and Hank is drawing out the questioning and making inappropriate remarks and stuff like that. Those are the biggest things of the day. Am I forgetting anything, guys? I don't think I am.
If these are two separate calls, can you explain to us why there is one timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar. Was it?
This table, no.
This information was taken from the infotainment system of the defendant's car, isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone, isn't that true?
Yes.
And so, you know why there would be two phone calls and only one timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Do you know that?
Yes.
Well, if you know that, can you conclude that even though there's two calls and only one timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's That's how it works.
So when you look at 530.15, bottom middle, and 530.52, it is impossible to tell which one relates to the 530.31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's two possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity.
Objection. I'll allow that.
Is there a 27-second disparity when you compare the two?
I'm not sure I understand the math.
Me either.
530.31 is 16 seconds different than 530.15 on each color. Yes?
Yes.
530.31 is 21 seconds different than the 530.15 color. Yes?
Yes.
And the difference is cut each way, one's minus, one's plus.
Correct.
So you add those disparities, you get 27 seconds, don't you?
Objection. I'm going to allow that.
No.
Okay. What do you get?
You're saying if, maybe, so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
how many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the defense card was turned on at 5:07 a.m.? Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change.
Thank you.
They move.
That seems reasonable, yes.
When I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay.
Thank you.
If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Sorry.
Yes.
If we turn to 10, please. Given, could you zoom in a little, please, on the left? Given that these data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30, did you consider whether they would be less reliable than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Hi, Janice. How are you?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 11:62 and 12:30, 1:43 to 48, than the 3-point turn?
Yes.
Okay. When he explains that
I already have a better one made that I'm going to be uploading tonight.
the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explained the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
I didn't have enough time to upload it before the live because of the motion to dismiss. But I will get it up as soon as the live is over, so you guys can play with it. Don't worry. I'll get it up for tomorrow.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
No, it's
Yes.
this.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one.
I'm like
I don't
2
remember
minutes behind
specifically.
Jody.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on
And
this.
that's a guesstimate.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy, or would you like me to bring it?
Do you
to
have the reports with you, sir? Okay.
Why would you jinx me like that? Not that I'd be worried about it.
Do you have an extra copy for him, Mr. Brennan?
Mine is marked. Let me see if I can get a clean copy from the witness.
But I gave him a very pink nose. The pink nose is very adorable. Totally adorable. Yeah, knock on wood. I feel like we're waiting for surgery and we're in a lot of pain. I just, with
I don't have a clean copy. I don't want to show you something that has my writing on it. Not that I care that you read it, but it's protocol. Okay. In discussing why this is not an effective way of matching the time, did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes. The
And when
call
he
logs
talks-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 5:30-31.
I think the opposite. I was about to say I think it's the opposite because of that. Yeah, and many other things. but yeah.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see Councilor Tadman.
Why didn't you ask him to hurry up, Bev? You asked the defense to hurry up every damn second you get, so why did you not just take that wonderful opportunity and ask them to?
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
Objection, Your Honor.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean
I
copy?
thought you said a coffee. I was like, can we have one too? Am I the only one that eats the peel on the lemons too? They're really good.
You can turn to page 3. What I read to you is where it says clock sync method 1. Do you see that?
Yes.
I'm the only one.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
I just want to point out
Yes.
I'm not the only one.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Well,
Because
I don't really slice up and put them into my drink, and then I eat them from there.
you still are under the mistaken belief
Sometimes.
that
Sustained.
Sometimes.
you still have the opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
So if we put up chart 12,
Jesus,
page
Hank,
12,
come
please.
on. I don't want to look at him anymore.
If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to
I'm honestly not sure
14,
anymore.
please. And if you could enlarge, well, I don't think you can enlarge it.
That's kind of like Hank's downfall. He thinks like he's literally going to pull something out, like you can't handle the truth moment. But what he's really doing is taking a very long, lengthy, totally not needed route, and we're staring out the window and getting caught by the trees and the birds in the sky, and he just doesn't realize it. Or he doesn't care. One or the other.
If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the 16, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
In the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that
You said
that
it.
distance is not.
Gabriel said it. Or so he wants everyone confused to discount the entire section of evidence. I've said the same thing from day one. I think that's his intention on every witness, that when there's a point up that he don't like.
As accurate as cueing it from the three-point turn event 1162-1.
The
think he
3-point
wants
turn
that.
is closer in time than the call at 5:32,
And thus more reliable, wouldn't you say?
generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea, not as reliable as the three-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the three-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the
Okay, have a
end
good day.
of the three-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes?
He didn't just have it in his head, he put it on paper
Right,
for all to
Christopher?
see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Okay.
Even me. Even me. I just dropped my lemon peel.
Exhibit 192A.
I really want to bang my head on the desk. Thank you.
Let's start with
Aw.
192.
You sent me your first gift that you ever sent. Thank you so much. That means a lot to me. Thank you.
A2B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the three-point turn event as timestamp 154, that actually is at the beginning of the three-point turn? Do you agree with that?
I don't
How?
know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you
Yes,
see
Liz.
the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
You.
And then the yellow is facing a different direction, towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
Hold the hell on. I don't think he went to kindergarten. Because I don't see a square. I see a circle. I see a green circle. Why the hell is he calling it a rectangle or a square? Wait, did I miss kindergarten and I'm just getting this shape wrong? You guys tell me.
And it notes that
So ask it differently, Mr. Brennan.
does that heading note the start of the three-point
Since you
turn?
asked me to rewind, I will rewind.
If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the three-point turn event as timestamp 154, that actually is at the beginning of the three-point turn? Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction, towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
And it notes that
Oh,
So ask it differently, Mr. Brennan.
Does that heading note the start of the three-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the three-point turn maneuver.
And then the heading of the change, end of three-point turn to O'Keefe's home, 12:24:07. You have any information to suggest that's not spot on accurate?
I did not analyze the three-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the three-point turn conclusion? Did you consider that?
I'm going to allow that, yeah.
Taylor, I hate to say this, but I don't even know anymore. I don't know.
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the three-point turn.
Yes.
Based on Mr. Burgess's May's report and based on the data, which you don't contest, you now agree that 154 was not the end of that three-point turn. It was at the beginning.
Objection.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
I know, right, John?
And let's turn to the previous exhibit so we can actually see the data that's broken down. You could open that.
He really wants to make sure he's got his $400,000 worth from his witness. He's not. No, this witness is going to be superior.
The
How dare
154
you question
timestamp, if
him?
you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Sustained. Strike it.
Hank, you're on a roll today. I think this is the most times you've asked a question that's been stricken from the record to date.
In the final exhibit? Let's go back
That's
to
not
the
a compliment,
data.
Hank.
You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you
Yes,
guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range? Objection.
So ask it differently, Mr.
Okay.
Oh my gosh,
You
good idea.
suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates the beginning of the 3-point turn, and then the orange is at the end when the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I
Asked
could
and
have.
answered.
But you didn't.
I did not.
Do you have any reason to test the accuracy of this data that's been broken? No objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, the wider range, right? Even though this analysis depends on the end of the 3-point turn, wouldn't you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the 3-point turn all the way to the end of it rather than just giving the end point? Objection.
As to that form, ask it differently, Mr. Brennan.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct?
And so if Aperture's position is the matching times at the end of the event, going back to the beginning, isn't that even more forgiving than being made scientifically? Objection.
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
The opposite of cherry picking, right?
Sure.
Do you have an opinion to a reasonable degree of forensic data certainty about whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is that text stream data would not reflect a collision, correct?
That's not what I said. I don't have an opinion.
Yeah.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
Say yes, please.
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
You're-
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
About damn time. Jesus. Sorry. Sorry.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could.
I didn't mean to yell, you guys. I'm so sorry. I was just so excited.
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
For the love of God, AJ, please say, but do you know who did?
Mr. DeSogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report, the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
Important point.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection with a chart?
It would.
Thank you, Tammy.
Thank you.
We're so close to 100K too. Right there.
Yeah, there are a lot. I would have to really use my finger to count them all.
Okay, more than 8.
Total after 1162-2.
Only on the 29th.
There aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, right?
Yes.
May I approach? Yes. And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you.
Thank you guys for getting us over 100,000 likes. That means so much to me. Thank you.
I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Thank you, Tammy.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2
Thank you, Chastity.
text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay.
Thank you, Rebecca.
If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12:32:09 to 12:32:16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you.
I do. When AJ went back up, yeah.
If you were told, to give you another hypothetical, if you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12:33:14, would that impact your opinion in any way?
Objection.
Sustained.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess?
Hold on.
Of course.
You need to, we have to turn the fans off.
And I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you.
It depends. If it's a mistrial, I believe she'll be tried again. If she's not found guilty, it'll probably never be solved, and that means no justice for John.
You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
Not specifically under murder, things like slander, stuff like that, yes, she can.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data, or his review of the infotainment system data?
I would too.
The 3 seconds came, well, fundamentally it came from the exemplar testing, where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed, for the infotainment system, I'm going to rephrase again, so I'm as clear as I can. When that button is pushed for the on event, the key on event, is that like a stopwatch? Click, a stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
It has a clock,
Are those two things independent of one another?
completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DeSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolk? Thank you. Did you create this table?
No.
I know.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess' report?
It was. It was a
Did you
screen.
type-
It was a screenshot.
Thank you, screenshot. Did you type a single word on this?
Or a number.
I did not. I added a green box.
Put a green box around it.
Yes,
You didn't type anything on this.
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection. Existing.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection. Existing.
Come on, AJ, you got
May I have
this.
just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down.
Shake it off.
What was your entire analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to Ms. Jerry during the course of the day?
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no.
Did you explain their analysis?
Yes.
Sustained, ask it to.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, in the presentation to the jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You're not alone, Missy. There's
You were
many of
asked
us in
whether
here
the
that do.
genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes.
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
That's correct.
You were also asked why you believed Mr. Burgess did a quote-unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes.
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting?
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
Don't give him another avenue to do this in. No. Not even a polite pass. Hell no.
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on.
This is a speech, not a
Start,
question.
start
It's
the question
cross-examination.
differently.
It is, it has to be a question.
Start. Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
No.
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, please, when you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
No.
I would say I'm reading the words that are in front of me and interpreting them for what they say.
Yes, poor Matt.
Someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone. That data then resides itself or resides on the implicated system, correct?
There's a transfer of data.
And
Yes.
so unless you actually do the study yourself, you had no way of knowing that information, although on the iPhone, on the implicated system, you had no idea whether it was from an iPhone or from the implicated. Fair?
That's right. I don't think that's.
And so when you don't actually do the work yourself, and you just presume, or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
One through five, and you're telling me right now, with reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself, rather than just Monday morning quarterback and somebody's report.
Objection.
So I'm going to strike it, ask it differently, Mr.
You
Brennan.
actually did the analysis yourself.
Nope.
More than
We're going to roll that back.
Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, put on 10, please. When you're looking at someone's report, you're guessing
Thank you.
as to what they thought or presumed, if you haven't spoken to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides on the infotainment system, correct?
There's a transfer of data.
And
Yes.
so unless you actually do the study yourself, you had no way of knowing that that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's.
And so when you don't actually do the work yourself, and you just presume, or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, are you telling me right now, with reasonable degree of data certainty, that that information is based on the infotainment clock? Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning quarterback and somebody's report.
Objection. So,
Monday
I'm going
morning
to strike
quarterback.
it, ask it differently, Mr.
If you
Brown.
actually did the analysis yourself, you wouldn't have to make a presumption that you'd be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Wilson's report?
no,
You don't know if that testing was done, do you?
I don't.
Objection, Your Honor.
I'm going to let that stand. Next.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer, frankly. I'm not sure how to give you a good answer to that
If
question.
you have the wrong data when you're doing your analysis, then the final analysis is going to be wrong. If you have using the wrong data, it's that simple.
Yes,
Right? You don't have to be a scientist to figure that out.
yes, that's
Okay. If we could have Mr. Welcher's 33.
I want to bang my head on the desk.
If you could open that up, please. You were asked about whether the windows within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I
I
see
want
vehicle
to, though.
speeds, right, in those first couple of lines, yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving, yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving, yes?
At the end of the record, there is a vehicle speed, the car is moving. That would be my assumption.
Okay. And so, when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data, yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window, yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay. And so after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time. Did you know that?
No.
And between 12:32, 12, which is in the 10-second window, and 12:32:16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay?
12:32:16, wasn't just that Mr. O'Keefe's phone was moving, there were steps made.
I didn't review the phone data, so I don't know.
Did you review anything to indicate that steps were taken over the course of immediately?
Objection.
So that's sustained.
You were asked just a second ago. What about the data? What is wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DeSoger, you are all set, sir. So you can step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
Finally, he's done. It took all day. Literally all day. Thank you, Redford. How are you? It took all day, but the first witness is finally excused. No thanks to Hank. Oh, I can't go again. Sorry. Honestly, I was having a hard time staying awake there too. Oh, I have no idea when the verdict is. They're not even done with their case being the case for the defense just started today. Come back in about a week and a half to 2 weeks. Yeah. You guys know that every witness that they call up is going to be this way, right? Every witness that they call up will be this way because his job is to make everyone have their heads so full that they cannot remember whatever the defense just said.
Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. And we'll start right around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise to the jury.
Thanks for wasting our day, Hank. It's over now. Yes, that sidebar turned into a dismissal. I know. I can't believe it either. I'm going to wait until the jury walks out because
We'll come back. I'll come back in 5 minutes for the voir dire.
they're having a voir dire. Don't go anywhere. But I'm going to go to the bathroom because I've had to go to the bathroom for quite a while. I drank my drink and I have to go. They're having a voir dire in 5 minutes. Don't go anywhere. No, I have to go to the bathroom. I can't fix for it. I have to go to the bathroom. I'll be right back. Oh, I almost took my phone with me. That would not have been good. Voir dire. I wonder whose voir dire it is. Probably Hank's. The man's looking for punishment for us. I feel so loved. Over 200 of you waited for me. Hold on.
Was now open, maybe.
Outside the jury presence, guys. Thank you, Redbird. Oh my gosh, that's so cool.
You solemnly swear the evidence you give the
Thank
court, the
you.
case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God. Thanks, you take the stand.
Who's that?
I know this is a elected opportunity. There is a witness outside. Just to get her.
Sure, is she right outside the door?
Who?
Do you mind, sir, if you can stay right there? Sure. It will just be a few minutes, okay?
I don't know.
Ms. Gianetti, when do you need this witness back? Monday?
There's no witness tomorrow. It's Monday. Monday witnesses again. And Monday, guys, we'll also be starting.
So I'm going to need her at a microphone. Do you have one on console tape?
We'll also be starting Monday at 9, which will be 8 Central Time, because we have Lori Daybell's trial starting next week. So there will not be patients with parameters starting next week. We have about a week and a half that we'll be doing from like 8 to 9 at night. 2 trials at once.
No, there's a microphone a little closer. Just follow the...
You're not the only one. I messed up too from today. May as well eat my last lemon slice.
Hi,
Damn.
good afternoon.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day?
Yes.
Mm-hmm.
All right, so we're not going to reach you today, unfortunately, but you were summoned to be here?
Yes.
All right, so that summons is still good until we reach you, so you're going to have to come back Monday morning, okay?
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay, thank you very
I'll write
much.
you
We'll
a
see you
note.
Monday morning. Be here before 9, okay?
Will do.
All right, thank you very much.
Thank you, Your Honor.
Love you too, Renee.
Go ahead, Mr. Lessie. Oh, geez, Yannetti, I'm sorry.
Thanks for wasting the day, Hank.
Compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up.
Sure, yeah.
I'm sure other people can hear you, but this old
So can
guy.
we turn off the fans and the air conditioning? Are they all on? We're just gonna do that, sir, so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduated high school with him?
yes,
And are you friends after high school as well?
yes,
Are
Do
you still?
you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes,
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me, okay?
Okay.
May I approach?
Yes.
This is a what here, yes.
Would you like this marked for identification first, Your Honor?
Yes.
Is it supposed to rain today, Illinoisans? I didn't even get time to check the weather. Why are you smiling and laughing, Bev? It says so. I don't want it to.
For identification.
Oh, hubby's still here. Hi, hubby.
And now we'll do it back to the witness.
thank you.
Because court's over. You family in Hinsdale? It's not horribly far from me. The whole time. You're real funny. Troll on somewhere else. Catnip, that was awesome. She's already Catnip said guess what and then blocked her. That was Catnip, that wasn't me. Not all cops, just these ones. Catnip is on the ball today. What they don't realize is when they come in and they type in the comments, that actually helps the live. And they think it hurts, but it doesn't. It actually helps the live. So, whatever. I know, I have to sometimes too. And you know when it's one of the ones that I have to play with before we cut it out. I can't resist sometimes. I just can't. Dude, why are you taking 500 years to read? I do too, but it gets me in trouble sometimes. I knew somebody was going to say that he was cute. You're going to bed, Parker? I think I totally missed something. This is Proctor's friend. They're like besties. They've been friends since they were kids. With friends like this, who needs enemies? Oh, to the store? Okay. Drive safe. Thank you.
I think he's all set, Mr. Newman.
Thank you, Ron. Sir, have you reviewed that entire document?
Yes,
Does that look familiar to you?
yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years, definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this.
I know you guys are pissed that I just paused it, but I just want to give you guys a trigger warning. The words that are about to be spoken are not the best of words. If you're in a public place, put your earbuds in.
You see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
Proctor's friend.
Do you have a passcode on your phone?
Thank you for the follow.
On my phone, yes, I do.
All right, and have you had that for years?
Yes,
So as of January of 2022, you would have had a passcode to get into your phone, correct?
correct.
With regard to the
Thank you for the follows.
typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page
Thank
numbers,
you,
they're all
Tammy.
numbered. Could you
Thank you for the follows,
direct us
guys.
to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end.
What?
And you don't have to read the actual text, sir. I just want to
Sure, I'm just trying to locate it.
I'm like all up in
Yes,
his
I see it.
business.
Okay, and the time of that, a date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you type,
Thank you, Tammy.
oh, I'm sorry, it's, to the record, it's on page, oh,
This is the defense that's questioning him. This is a voir dire, and this is Yannetti. I really do need to make him a
and
sticker.
for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
We knew that
Now,
already.
going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
I don't think it's necessary. Yeah, so let's not, if he recognizes, I don't want to put names out.
Oh, I don't either, Judge. That's why I was saying first names, but if that's sufficient that he.
A voir dire happens when they're trying to argue evidence in or a person's testimony and so on and so forth. That's what they're doing here.
Recognizes.
Why don't
The
you,
jury is not present.
refer to the last two digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last two digits
You're welcome.
of the phone numbers that don't have a name associated with them, okay?
Okay.
If I may just have a moment?
Yes.
Yes, I literally just put my makeup on for you guys every single day. Nobody else sees it.
Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
We're
And-
having a voir dire right now. The defense is the questioning party.
With regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
Yeah.
of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are three numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
It's a zombie mask
Those
kind of day.
nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a, complete, accurate record of what it purports to be. What is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
I don't know.
If I may have a moment, Your Honor.
Okay.
I didn't watch the first trial. I've started watching bits and pieces of it since we broke our oath, but I don't know. Okay. Shall we begin with the zombie mask?
The text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Childhood friend.
Mr. Brennan?
He was in that text chain.
Good morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
The hell?
Nothing like that.
All right, so sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay, thank you.
Your Honor, given that, unfortunately, this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right, sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So sir, you can leave.
Okay, thank you.
All right, and thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
All right. We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I've got to respond to the objection.
I want to hear you as to why this is admissible.
I have all of the trials on my YouTube. I put them up after we're done every day. Michelle's Criminal Musings. You can watch them all there. I don't know. I think we're about to find out. No. I'm guessing he was advised to. But that's a guess. Guys, do you do face masks too? I need to know
So,
for
Your
my guys in
Honor,
here.
with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding
Snotty much?
authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rules of Evidence 901B1, 4.
If you want me to link, you just send me a message after the live and I'll send you the link for it.
Evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend.
I love the TikTok shop. The TikTok shop is great. You guys love it too, right?
Was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell
Not using
phone
safe words.
were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid, black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing.
Do you guys want a sticker? If you guys want a sticker, Mitty and Eddie, I'll do it.
In terms of
He's
what
pretty
they
good, yeah.
represented it to be. They stated that in Welch, the court must find that
That's
each
sort
and
of what
every
this is.
communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in, again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there.
You guys, my resting bitch face won't work. It's stuck this way. I can't use my resting bitch face.
nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites 3 principles. It's almost like they're setting a standard down that the court is supposed to follow with 3 factors. But again, none of the 3 principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes, okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay, so I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has 3 components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner is not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our...
He's not questioning, sorry, I can't move my mouth much. He's not questioning, it's a voir dire.
Defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's gonna go down for this. We're gonna pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
Do you guys want to see why this is called the zombie face mask? Click for real see.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you, Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
I can't believe I did that with over 200 people in here. It's so much fun.
On the first issue of authenticity,
Yeah, because I can't use my resting bitch face. That's how tight it is. I can't. The smile is stuck here because of the mask. It's not by choice. I would not be smiling for this man.
this witness has no memory of any of the text messages.
Mm-hmm.
I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity
Once a week.
if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in some of the substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But
Catnip, they got a new one. This is the new one. I haven't opened it yet. If you
really,
want the link,
you need
just
to put
message
that
me.
in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these
Link me. I need that one.
messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for 1.5 years. That defeats the purpose of defining the value for which this is being omitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with
I
bias.
did that too.
And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay.
I was trying to give him a dirty look this whole time and I couldn't do it.
And Eddie, do you want to respond?
I know we're, we're late, Your Honor. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note, Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit.
We don't know who started it. They've had it for years upon years. They're childhood friends. And yes, I love this mask. I love it. I use it all the time.
Text messages, that's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay, and just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
I do it once a week.
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing to be turned over as not repeating.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have an obligation to do that. We have an intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
Rise to the court, please.
So we don't know. We don't know what her decision is. They have to get her documents. Honestly, the way she ruled from the bench this morning, she didn't give any thought. So maybe for once she might give some thought. It hurts to yawn with this mask on. I think Bev is part of the plan, but that's just my opinion. Keep in mind, you guys said it was her brother, right? That represented Chris Albert in his 94 DUI manslaughter case, where he then there was a manhunt for him. He took him on a police chase. That was her brother. You can't tell me they're not connected. Was this 23 today? Let me check. I'm sorry, 24. Bev's brother. Bev's brother represented Albert. Here, I'll show you guys the legal documents. There's one. Mm-hmm. I can't read that on my glasses, and even if I did, I wouldn't put them on my face with this on. Yeah, she refuses. 100% she does. Here's the police report. I'm planning on putting this all together in a video. I just didn't have the time I thought I did this morning because exactly. I don't always look this way if you guys are just coming in, I promise. This is a face mask. So, yeah. This one, it's by Beauty. This is the zombie face mask. This is the new one, Catnip, the new box that they have. I haven't worn the specific one. I have my old box that's still full. If you need the link, just message me. Oh, this hurts. This yawn hurts. That really hurt. That's something that many of us are worried about too. You know, I'm right behind you with that nap. So this one, this tightens and lifts. That's a good question, MJ. I wish I had the answer. This is a tightening and lifting, pore tightening and lifting. One time I did the mask and this eyebrow ended up higher afterwards than this one. So you gotta make sure you put it on even. You know, I've wondered 5 million times. I didn't wonder about, I wondered about, sorry, that really hurt. I wonder when Ashton Kutcher is going to jump out and say, punk. Because it would have to be punked, right? Because this can't be our reality. If they could do this to her, they can do it to us. Now that over 200 people have seen me look like this, I'm going to go take my shower and scrub this all off. I hope you guys have a good night. I don't know if I'll be on tomorrow. Haven't really decided yet because on Monday we start our... On Monday, guys, we'll be starting at 8 Central Time. We will not be practicing patients with parameters because Lori Daybell's trial also starts. So starting Monday, it's going to be crazy. Yep, 8 a.m. Central. Well, if he pardons Diddy, he's a damn fool. Have a great night, you guys. Thank you so much. I appreciate you, and thank you, moderators. I love you all, and thank you for all those likes. I totally love you guys. Bye.